Now, I would request Shri G R Raghavender ji, who's Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India, to please enlighten the audience on his viewpoints, on his valuable viewpoints about the IPR issues India is facing. So let's welcome on stage Shri G R Raghavender ji.
Vande Mataram. Good morning to all of you. Respected my friend John Kabeka and other distinguished guests on the dais and my brothers and sisters from IP community. So, namaskar. And I would like to congratulate NASCAP for organizing this brainstorming session. You all be participating, discussing various issues, and various experts will be coming and then sharing their views on the important issue of IP enforcement. And today's topic is Conclave on Special 301 report. You know, I got educated in IP when in 2007 I was made to sit in the seat of Registrar of Copyrights. And then first thing which brought to my attention, apart from the agenda of amending the Copyright Act, which of course we successfully did it in 2012, but the major issue was the moment I joined, a huge delegation, 7-member delegation came from the US, and he was assistant USTR, that team was led by, and various experts on copyright subjects. And I was new, just 2 months old in the Copyright Office, facing them. So then I understood the importance of the technology, the online network, the kind of piracy happening. What should India focus in the bill we going to introduce in the Parliament amendment to the Copyright Act? You know, how this 301 report is made and submitted to the USTR, and every year they release it. It basically covers domestic industrial IP interest of United States of America. Whether the manufacturing industry, manufacturing may be various sectors, mechanical, electronic, pharmaceutical, and IT industry, and to the creative copyright industries, of course, who won't see the Hollywood films and the music and various things happening. And nowadays the artificial intelligence issue is a big thing. After Stephen Thaler started submitting his patent application all over the world, IP offices getting rejected, and including the US Copyright Office said that, you know, Rembrandt is not allowed to make that painting. Only a natural person gets the copyright, not the machine. Okay, all these things are happening. So why this report comes out? Because US is worried about their industry, the growth of their industry, and protection of their IP. What it says in a gist, if IP is not protected as per the international minimum standard to which America is a member, not only the America, which is a member of WTO TRIPS, the other members also should respect the minimum standards. If somebody is below that standard, when, you know, in this globalized world, you need not export your things physically, and many online networks make that content available to you. And if any infringement happen, whether infringement of copyright content or infringement of trademark goods or infringement of patents, especially they're worried about the pharmaceutical industry, infringement of their patents and all that. So they say that if any damage happens to their IP, that will have serious impact on the growth of their industries and those industries' contribution to American economy and the job. Because if anything goes wrong, the industry has to close because of piracy, that will have impact on the employment. So where those employees will go. So similarly, the way America has interest in their industries, IP industries, India similarly has such interest, and Indian laws do protect uh, patents, designs, copyright, and trademarks, and we follow the minimum standards to the core. The all intellectual property treaties and convention. If you look at the TRIPS agreement, Article 1 clearly says the member countries should follow the minimum standards. Okay, we follow those minimum standards. But the problem but how these minimum standards are interpreted? Because while negotiating in the Marrakesh, in 1994, when Marrakesh agreement was signed and finalized by the WTO countries, what they did, they knew the entire world there is an asymmetry in the economic development, industrial development, technological development, and that has impact on the growth of these countries. That way, that is the reason why United Nations categorize the entire 192 nations as developed countries, developing countries, and least developing countries. So when TRIPS became effective on the 1st January 1995, it says if countries like India, which are developing countries, they will get 10 years extra time to harmonize with the minimum standards because they have to equip themselves technologically, and all industries have to get ready for that. Similarly, longer time was given to least developing countries. Now that goes on. Extension is being given to poor countries like Bangladesh, for example. That extension, if I'm correct, in 2036, I think, if I'm correct, that goes on. That's why when other day the TRIPS waiver, the famous patent waiver, was approved by the WTO. Then one of the arguments of the developed nations, look, there is already provision of allowing least developing countries not to follow these things. They have already got a patent waiver till 2036. Why do you need a patent waiver? But do they have capacity to take a compulsory license and manufacture messenger RNA vaccines like Pfizer or Moderna? The kind of complicated technology, pharmaceutical technology involved in the various stages. It's not one-stop shop. Various ingredients are made in the US in various locations. And somewhere the raw material, the API comes, and then various stages it is developed. The final stage happen maybe in the major Pfizer company or Moderna company. So that kind of technology, manufacturing capacity, countries like Bangladesh, I don't know. Even India, considering this, the problem in that, of course, we did ask for the TRIPS waiver, not only for the patent, for the copyright, for trade secret, and the design and trademark. That didn't happen. Finally, we got a watered down TRIPS waiver that is only for the patent. But we have our own Atmanirbhar Covaxin. Recently, I took my 3rd dose in the CGHS. And next week, we are organizing a small mela in my Department of Justice. Those who have not taken those, including their families, are welcome. The employees only, not the others. So they are, because of course the Prime Minister has declared that under this Azadi Ka Amrit Mahotsav, 75 years of independence celebrations. So some date has been given. During that date, every citizen will be given free, of course, already government in government hospital, the vaccine is given freely, but still, those who are going and paying in the private hospitals also will be given this dose freely. But coming to USTR discussion, so this way they protect their country interests, their industry interests, protect their intellectual property, and how that has to be enforced and managed. The same mechanism we follow. So when both countries are TRIPS members, then why this divergence? I already told you TRIPS flexibilities allow divergence. There is a convergence, 192 members of TRIPS. Because of the flexibilities, there is a divergence. One, it gives, okay, minimum standards you follow. Article 1 of the TRIPS. It again says countries who want higher standards, they can go ahead. So strong IP, people talk. These intellectual IP experts say that if you don't follow the strong IP, your investment in your country will not happen. If India is priority watch country for the last 10 years or so, what is the damage happened to US industries? Pharma industry, film industry. How many employees have gone unemployed? What is the amount of loss they have got? We have no record. So if India is damaging their industry, do you have a data available with you? How many got unemployed because piracy happening in India? And how many industries have been closed, pharma industries? I'm coming to that. Then stronger IP you talk about. If India is in a priority watch list for the last 3 years, of course, since the Honorable Prime Minister Modi has taken over, I'm talking about from 2014, India has become a strong hub, a destiny for foreign direct investment because of the change in policies. Now, most of these sectors, FDI is automatic route. So you need not follow FIPB route. So India is the leading FDI country. You know, the last year data, despite COVID lockdowns last 2 years, India is the leading FDI country. 83.5 billion US dollars, mind-boggling. It is not our data, the international IMF data, World Bank data, if you just Google and you'll get it. And now considering this, what is our aim for this year or coming years? You know, in government, we are planning, we are celebrating 75 years of independence. Azadi Ka Amrit Mahotsav. So if you remember, now the 15th August is coming. Those who remember Prime Minister's speech from Red Fort, 15th August last year, what did he say? We have been achieving so much in every sector. In even COVID also we faced. We have our own vaccines. And proudly declared from the UN General Assembly meeting session that India is the first country to manufacture DNA vaccine. In nucleic acid varieties, RNA and DNA, US and other countries have made RNA vaccine, which is very complicated, very simplified, most effective DNA vaccine. India is the one, Zydus Cardula, again a generic company. I'm coming to that area about the 3D and generic briefly. I'm not going to take you much time, but my personal comments on this, because I dealt with this Super 301 report. I do have respect for the US because I learned a lot in the IP through my friends like Professor Justin Hughes and others. And the way they are doing is also we should replicate, in fact. We should protect our industries. We should come out with a report and how other countries are damaging, because we have a huge pharma industry. India is a pharmacy of the world. It has been before, not because of COVID time. COVID time, it has been reinforced, that name, that India is a pharmacy of the world. So many leading countries did not have paracetamol. They did not have hydroxychloroquine. These are simple medicines we gave them. And most of the 100 countries, free supply we have made. Of course, rich countries like America, and of course, it is a typical trade. And then coming to the vaccines we made, whether it is Covaxin, our own Atmanirbhar, or the non-exclusive license we got from the AstraZeneca Oxford vaccine, that what we call the Covishield, which Serum Institute of India Pune makes, that also we exported. Both Covaxin and Covishield, we freely gave it to poor countries and many middle income countries, developing countries. Of course, we contributed to COVAX facility of the WHO. Only thing we have to stop is because in the COVID-2 wave, and we have to take care of our domestic conditions because of the way COVID-2 wave created havoc. And unfortunately, that time, when we needed vaccines and to protect our people, the country stopped allowing to us to import their raw materials, the API needed for that. So there was some problem, and then finally, lot of negotiations, they lifted the ban on exports, and then in flow started. But in the meantime, again, the Bharat Biotech Hyderabad, which makes Covaxin, they started investing in preparing their, again, just like it's Atmanirbhar vaccine, Atmanirbhar API, the raw material. So, and we should not depend on these things. You know that the open secret, the paracetamol, the 10 रुपए का 15 रुपए का पत्ता मिलता है. If China stops sending API, we can't make that. So we should develop Atmanirbharata. Not only Atmanirbharata, when we invent and innovate these things, we should protect them. The patent should be protected. The way strongly US follows protecting their patent, pharma patent, we should be doing the same thing. We should get inspired from the 301 report, and it's a win-win situation. They also get benefited and we also get benefited. So how this happening? Because it is not a counterfeit medicine or a pirated medicine generic, you know that. All these companies are existing because of Indian laws have been made, following the TRIPS flexibilities. I take you when many countries criticize the flexibilities, how developing countries made their law. Doha Declaration happened in 2002, clearly stated there that the TRIPS provisions and interpretation of these provisions do not and shall not come in the way of domestic legislations made by the countries, member countries, for considering the public health issues and access to medicine issues, whether you're introducing compulsory licensing as per Article 31 of the TRIPS, that is allowed there. And then coming to the international exhaustion with the patent allows. Article 6 of the exhaustion article in the TRIPS clearly says there is a flexibility. You want to have national exhaustion, regional exhaustion, or international exhaustion. We adopted in the international exhaustion, parallel import of cheaper medicine will happen. It's not infringement. Whereas in copyright, we said no, because we are the third largest publisher, English publisher, and sixth largest publisher in the world, and we publish books. Already our rates are very cheap, and even foreign publisher publish in India is a low price editions they do. So if these, again further cheaper thing comes, all these get damaged. The entire publishing industry interest get damaged. So for the national interest, we introduced national exhaustion for the copyright. And then Delhi High Court in a Penguin case, in any case, the lawyer must be knowing how it has been protected. Again, trademark, we have international exhaustion because we know ours is the largest market in the world. Everyone comes here. No manufacturer can survive ignoring India. And similarly, the reason why we introduced international exhaustion, of course, the trademark one is under challenge. That's a different thing. But still, patent, we for the cheaper medicines and cheaper goods. Cheaper means genuine goods, not the counterfeit goods. So these TREPS facilities India adopted to promote our policy of access to medicine, cheaper medicine, affordable medicine. The national list of essential medicine, which Department of Pharmaceutical brings out every year, even during the COVID times when unscrupulous and anti-social elements started hoarding essential medicines like remdesivir. And each vial, they said, 60,000 rupees, 60,000 rupees, 1 lakh rupees, black marketing. Indian government immediately brought out, if it is a foreign made, what is the price? Indian made, generic, what is the price? It's been clearly, rates have been fixed. So TRIPS allows that flexibility. Again, it's not the violation of TRIPS. And this is what we have been following. And lastly, the 3D. Why 3D? 3D is there. If you see that 2013 report to till now, 3D continues. Because they know it is their policy, it is hurting them. And also data exclusivity, which for 5 years they give, and also the patent linkage, which they allow. These are all TRIPS plus interpretation. If you see the seminal work, if you read the seminal work of Carlos Correa, he has written this report for the UNCTAD, United Nations Council for the Trade and Development. He says the way the data exclusivity from Article 31(9), protection of undisclosed information, especially test data has to be done, it has to be protected. How? India says no misappropriation should happen. So that is infringement, that is protected. But the interpretation is data exclusivity. You have to lock it for 5 years, US says, EU says for 8 years, Japan and China says for 10 years. So it is a TRIPS plus, that is the UN document says, UN report says. So we don't follow the TRIPS plus, we follow the TRIPS interpretation. So 3D, which Supreme Court has clearly clarified in its judgment, I don't want to go in, the why it says that any new form of known medicine cannot be patented. So there is I'm a chemistry student, I know in a benzene ring, 8-cornered benzene ring, one salt you have put in addition, that alpha salt you remove and you put beta salt, they say there is enhanced efficacy from paracetamol to paracetamol plus. Okay, now it is paracetamol plus. Paracetamol patent exhausting, I will come with the paracetamol plus. Give me patent. Means your patent extension is happening. There is no efficacy in that. How it is going to relieve my pain. Is it really going to relieve me just one tablet? No. Doctor again will say morning one, evening one. Agar zyada ho gaya to SOS, you take one more. It was with the paracetamol and same with the paracetamol plus. And how the therapeutic efficiency has increased. God knows. But patent examiner says, yeah, there is an inventive step, give them a patent. Plus is qualified for the patent. This is what 3D says, no. You're simply giving a patent extension and stopping a generic medicine company to produce it after the patent exhaustion happens. And coming to text data linking with the patent linkage, which again in the CIPLA versus Union of India versus the famous company I forgot. And the Delhi High Court clearly said, the Drugs Act and Patent Act provisions have to be read separately. You can't read them combined manner and interpret that there is a patent linkage in India. So what I'm saying that if you see the entire history of 301 report, I grew up with the request for the optical disc law in 2013-14, जब हम लोग डिस्क खरीद के लगा के कंप्यूटर में या समवे में लगा के सुनते थे गाने, वो तो सो डिस्क की पायरेसी होती थी, उसको रोकना था. Then no physical. Who is buying CD? हाथ उठाए. Please raise your hand, those who have music CDs, those who are buying. Now, industry has gone, and US stopped asking us to implement optical disc law. When they were asking, was there any law in America? No. Why you want a law in India? Because India में piracy ज़्यादा होता है. And then came internet, everything became digital. And a country called France, they introduced graduate response in law, 3-strike law. What is this? If you unscrupulously upload a video against the interest and permission of copyright holder, ISP will give you one warning. You do second mistake, they give you second warning. Third mistake, no warning, your internet connection gone forever. You are blacklisted. That is called Hadopi law in France, they implemented. And many countries got inspired. New Zealand, South Korea, Taiwan, even British, UK introduced digital copyright bill. They introduced this provision in 2010. Then all this delegation coming to India, मेरे कमरे में आके बैठते थे. India should introduce. So immediately my brothers in the US delegation, I asked to ask them, भैया आपके पास है कानून? No. So why do you want? No, you have a copyright alert system. Our motion pictures and others, they are doing it. What happened to copyright? Then the delegation started saying, there is a data that it has successfully reduced the piracy. But another report came that, piracy has reduced not because of Hadopi law, because iTunes download rates have come down. 500 रुपए का महीना था, वो 100 रुपए कर दिया. तो ऑब्वियसली मैं पायरेट क्यों करूँ? 100 रुपए में वो मैं भी शरीफ बन जाऊंगा, 100 रुपए लगा के और लीगली डाउनलोड कर लूँगा. तो ऑब्वियसली द पायरेसी हैज कम डाउन. So there is no data to. Finally, Rebecca Millian, if I exactly, she came with a seminal research on all these 3-strike laws, whether it is copyright alert system, Hadopi law, New Zealand, Taiwan, Singapore, Hong Kong, and UK law. What she has concluded based on the data available, there is no direct link between the reduction in piracy and implementation of these laws. Despite these 3-strike laws are there, piracy is happening, they have not succeeded in decreasing the piracy. No, I'm not ridiculing these laws. With all respect to those countries, the respect to those copyright content creators who want to protect their economic interests, they failed to implement these laws. That's what she says. There is no direct linkage. Number 2, she concludes with the data. With all empirical evidence, she showed that it has not decreased the piracy. Then what we should do? Just to laugh at them and then allow the piracy? No. So coming to India, what we have done in 2015, introduced Commercial Court Act to fight the piracy and infringement and protect the IP industries. So these Commercial Court Act and commercial benches were introduced in the high courts. Commercial court, district courts were started. When World Bank was assessing Delhi, Mumbai, So I had to run between all the top higher echelons, get the 2018 amendment ordinance first, then act later, to creating a dedicated courts in Delhi and Mumbai. Delhi started with 22 courts effectively functioning, and Mumbai 6 courts. So how these courts function, you need not go and file a case first, any copyright trademark. And if you need any interim relief, then only you for litigation, or if possible, pre-institution mediation within 3 months you can do. Otherwise, you have interim relief because you know a lot of economic loss happening, then you can go and file it and get an injunction. Then how this happened, there is a pre-trial conference called, we call it case management hearing, specially amended CPC only for commercial courts. Order 15A introduced. What is, in one hearing, normally advocates know, sir, मुझे written statement नहीं मिला, मुझे copy नहीं मिला, मुझे reply नहीं मिला, adjournment. Then comes evidence list नहीं मिला, witness का list नहीं मिला, again adjournment. So what happened, pre-trial conference in one sitting, everything exchanged, and the issues are framed, and then next hearing argument will start. And then that also limited time has been given, and the way this has been expedited. Delhi has brought down from 1445 days to 700 days, Mumbai 600 days. So you see the difference. So now, because of some fudging in data happened, I don't want to name the country which did, and World Bank finally has to abandon the UODB. Now, but we are continuing with this assessment. We are going to assess entire India's commercial code, because when my brother John Kabeko says that their motion pictures piracy happen not only in Delhi, Mumbai, remotest of the remote village may happen, because wherever internet access is, we need to protect not only their interest, our interest, because the Bollywood industry is the #1 industry in the world. And the regional industry, like I come from Andhra, the Telugu industry, whether it is Pushpa or Bahubali or RRR, they have become world leaders. And then coming to this, but we are trying our best. When amendment was there was a late thinking that we should introduce a provision in camcording, which US TR and the US delegation have been asking. Not for that, laws are made and the policies are made for the country, development of country, protection of the industry, promotion of industry, and the growth of GDP and economy. But here, some laws, win-win situation, not only for our stakeholders, their stakeholders also. That's best example, introducing ComCard law. Because it was a late development, legally it was not allowed to be inserted in the bill at a later stage. Then we said, let INB handle. They are included in the cinematograph amendment, and perhaps, if not in this session, at least in winter session, it will see the light. Then coming to these things, then there may be high value stakes in IP. Then we want urgent hearing for that. So following PM's investors meeting with investors all over the world, we requested all the high courts, please create one bench, dedicated bench of high value, 500 crores above. Is there? Please create a special bench. Delay should not happen. They have done that. All high courts have done that. Coming to Delhi and Mumbai, they have done a smart job. How about 100 crore? They have made a separate bench for 100 crore. Delhi has gone further step. The recent latest USTR 301 report mentions about abolishing IPAB. The reason why it is under the tribunal reforms which government is pursuing. Tribunalization happened, which Supreme Court and again said, why so many tribunals have been set up? Though appointing the people is a big problem. Sometimes tribunals are not centrally located, not accessible. I don't know why it was, IPAB was with the headquarters set up in Chennai. You know why? Basically political reasons. I don't want to go further more than that. And no judge or a retired judge was ready to go and sit there. Only, we were finding a right person like Justice Prabha Sridevan was difficult. She is the best ever chairperson for the IPAB ever had. And we can't get a person like that. And if we find that person, he is not ready to go and sit there. And the moment you decide to bring that to Delhi, you know what will happen. From Chennai to Delhi, वो आ गया, क्या होने वाला है आप सबको पता है. And that is not done for the political reasons, for the industry interest, for the lawyer community. It's not done. And we can't go on build when one person you are not able to sit there. And then pendency was piling. And people talk about they were experts. Tell me, one patent expert member, he may be from mechanical. If you appeal for the IT patent, pharma patent, or any biotech patent, a mechanical so-called expert sitting as a member, तो समझ आएगा? No, I have studied botany, zoology, and chemistry. Even though my PhD thesis on IP, AI, and text data mining, both मेहनत करके सर फोड़ना पड़ा. But I can't go and with this knowledge, I can't become a patent examiner. Even though tomorrow post-retirement I become a patent agent, I may be concentrating on the botany, zoology, chemistry, these things only. I won't be doing just that. How a mechanical member, IPB member, will do justice and help the chair in taking a decision on a pharma. And let us say, so many pharma cases which IPAB has done. So, moreover, pendencies. So let equip the high courts to do this job, because tomorrow appeal goes to Supreme Court. Again, these judges will be sitting on promotion in Supreme Court. So there is a continuity is there. And Delhi High Court has come out with a great step the moment it has been done. They have created an IP cell. They have appointed experts, just like patent office, IT expert, pharma expert, even the copyright expert, few professors, interaction, these things. These things are happening. Other high courts have to continue this. And, these are the important issues I just wanted to highlight. With all respect to US 301 report, of course, they have their own interest, economic and IP interest to create that document and point out to other countries. And we know that we have to do that. Finally, I want to say that it also says that there is no trade secret law in India. For the past 10 years, only one voice is talking in the government. It's mine. That India should introduce trade secret law, because it is bad. Especially the Make in India Prime Minister's program, the Atmanirbhar, and also the Atmanirbharata we are saying, domestic field, with a change of cutting edge technologies are being introduced. Lot of data is being generated. We don't have a non-original database protection act like EU. If you see the Supreme Court judgment on Eastern Book Depot versus DB Modak, which followed the fierce publications versus rural telephone of US judgment and the originality of the copyright. The similar judgment Indian Supreme Court gave, similar to US Supreme Court, non-original databases, there is no copyright. Originality, there should be mere degree of creativity, followed by skill and judgment. So when this happens, when it is not copyrightable, the lot of investment happening in that database, commercial interest is there, there is secrecy is there in that. Only trade secret can protect. Both civil and criminal remedies should be given. Then coming to the technology, we have a 3K. Again, just like our flexibilities allowed out to, in the Patent Act, allowed to become a world giant, pharmacy of the world in a generic, cheaper, affordable, legal medical industry. I'm talking about legal. They are not counterfeit. Generic medicine is not counterfeit. And here, IT industry also grew because of 3K. Only computer program which is making a device function, just like similar to Ally's decision of the US Supreme Court, abstract ideas cannot be patentable. The software or algorithm has to make a device to function, or functionality has to improve. Same concept we have follows, our courts follow. But recently, Supreme Court said that you just and then just remove your recent computer-related invention guidelines. It advised the CGPDTM office because it is not protecting the innovation. The old guidelines do that. Even though it's under 3K, we should follow that. I am fully with the Delhi High Court judgment in that, because you can't stop even the algorithm which making a device function, because a 3K algorithm not patentable, not invention. So in fact, it is not patentable. What happens? Trade secrets should protect it. Again, the things which are not patentable, things which are not copyrightable. So I fully, from this forum, now I'm not talking on behalf of government. As G R Raghavender, I'm saying that India will benefit. Indian industry, Indian startups, Indian innovators, both in patent and copyright sectors, they will benefit if we introduced. And the last one, we have to amend Design Act. It is very poor. It doesn't have criminal remedies, civil remedies. They are very minimum. They are not deterrent, and that should be strengthened. And India should also join Hague system. Because when you are providing international protection under trademark Madrid agreement member, and under patent cooperation treaty, you allow international application patent. You should allow for the design, because Make in India is happening. First thing you go to market, design appeals to you. So if that design is not strongly protected, we have a weak design law, it is not done. Okay, thank you, Jai Hind. I think I've taken a lot of time.
Thank you, sir. Thank you so much for your enlightening words. As you rightly mentioned that you're the only voice who's willing to introduce the trade law secret in India. We wish that a lot of new voices join you in this journey. So let's have a big round of applause for G R Raghavender ji. Now I would request Honorable G R Raghavender ji to felicitate and recognize Jotwani Associates, a New Delhi-based law firm, as being among the top firms to enforce IPR rights in the software industry. Jotwani Associates closed around 725 anti-piracy cases last year in 2020 and 2021. And NASCAP would request Dr. G R Raghavender ji to please present a memento to Ms. Harpreet Oberoi. Let's have a big round of applause for Harpreet ma'am and Mr. G R Raghavender ji. I would request one of the volunteers to please come in the front and present the memento. Come on everyone, don't stop clapping. Thank you so much. Now I would request the Honorable Sir to please felicitate and recognize the online platform IALM that has imparted online legal and management education to thousands of students across India. Ms. Prerna Rawat, Vice President, would receive this award on behalf of IILM. So I would please request Ms. Prerna Rawat to please come on stage, and I would request Shri G R Raghavender ji to felicitate IILM. Let's have a big round of applause for IILM. I think there are some ex-students of IILM also. Please, guys, have a huge round of applause. Thank you, Ms. Prerna. Thank you so much, sir.